Welcome to the deep dive. Today, we're tackling a really fascinating and honestly a kind of chilling premise about something a lot of people do to feel safer.
Right, firearms training.
Exactly. We've been going through a ton of research that suggests the wrong kind of training, or even just, not enough of it, doesn't just leave you physically unprepared.
No.
It can actually become the biggest piece of evidence used against you in court after you've had to defend yourself.
It's a total flip of the script. And our mission here is to really understand how that happens. We're focusing on this deep analysis of the concealed carry training market, especially in places like Florida.
Or it's just exploded, right?
It's exploded. The sources call them permit mills. So we need to pull out the 7 specific mistakes that create these huge legal liabilities, the ones that can just shred a person's credibility in both criminal and, later on, civil court.
So we're shifting the focus completely. This isn't about, getting a tighter grouping on a paper target.
Not at all.
It's about achieving what the sources call legal defensibility. Your training record is basically this ongoing deposition that will either prove you were reasonable or prove you were negligent.
Let's start there with the absolute foundation of the problem, relying on the bare minimum.
Yeah.
That's mistake number 1. Treating that basic state-required class, the CWFL class, as all the training you need.
In a state with permissive carry laws, that's so tempting to do. You take the class, you fire a handful of rounds, you get your certificate, and you're done.
But what have you actually proven?
Almost nothing. It's a very low bar. It's really just designed to show, basic safety rules, not that you can handle a fast, dynamic, high-stress situation.
And that is the exact weak spot a prosecutor will go after. If your entire documented history of learning how to use deadly force is one 4-hour class and, say, 8 shots at a target, they'll frame you as barely trained. Or, my favorite, technically compliant, but tactically negligent.
Oof, that's a powerful phrase.
It is. They argue you just checked a box, but you never actually invested the time or the effort to be truly responsible. That one little certificate becomes this negative story they tell the jury.
That makes perfect sense. It's not just about what you can do, but what you did to prepare. And to fight that narrative, the sources say you need a documented progression.
Yes, a paper trail.
Not just the basic class, but things like pistol fundamentals, maybe night fire or low light training, and the really important one, scenario-based training. You have to show you were committed.
And who's teaching you is just as important. Which brings us right to the second big mistake. Training with instructors who are just certified and not actually licensed or, recognized by law enforcement standards.
This one is tricky. People see a patch from a big national organization like the NRA or USCCA, and they just assume that person is a legal authority.
Right, a total authority.
But the sources make a huge distinction between that and being, say, a licensed firearms instructor in Florida, or even better, a current or former law enforcement instructor who knows about investigations.
Because the instructor's credibility becomes your credibility. A certified instructor is probably great at teaching you the mechanics, grip, stance, sight picture.
The fundamentals.
The fundamentals. But a licensed instructor, especially one with a law enforcement background, they understand how a shooting is actually dissected by investigators. If your trainer taught you some, high-speed drill that looks cool, but is tactically unsound by police standards,
then you're in trouble.
big trouble. The opposing counsel will argue you were trained to be reckless.
So the expert witness on the other side doesn't just attack your actions.
No.
They attack the curriculum you paid for. They'll ask, so your instructor taught you to fire around a corner without knowing what was behind it? Is that what you consider responsible?
Precisely. The training has to be grounded in defensibility, not just entertainment.
Yeah.
You need to understand the use of force continuum, the legal side of every single decision, not just how to shoot fast.
Okay, so if the classroom sets the stage, let's move to the range. This is where we get into ignoring real-world conditions. And that brings us to mistake number 3, never training in low light.
This is maybe the biggest tactical gap there is. Study after study shows most violent encounters happen in reduced light.
Dusk, dawn, inside your own home at night.
Parking lots, hallways, and yet almost all concealed carry training happens on a bright, sunny day at a flat range.
I can just hear the lawyer now. They pull up your training log and it's all daylight. They just say, you failed to prepare for the environment where you are most likely to need your weapon.
The implication being that you couldn't properly identify the threat.
Right. That you couldn't be sure what you were shooting at, which puts bystanders at risk.
And that risk is the whole legal case against you. The sources are so clear on this. Training has to include realistic low-light work. That means using flashlights, both handheld and weapon-mounted.
It's not about having cool gear.
No, it's about proving you were trained to see, to assess, and to confirm the threat before you pulled the trigger.
Yeah.
That ability to confirm, I saw the knife, I confirmed he was a threat, is everything to your defense.
And that awareness of your surroundings links right into mistake number 4, ignoring bystanders and your backstop.
It's overlooked all the time. Shooters get tunnel vision on the threat. But while the criminal case is about your justification, the civil lawsuit that follows is almost always about unintended consequences.
Stray rounds, injuries to innocent people.
Exactly. If all your training was just about putting holes in paper, a plaintiff's attorney will argue you were reckless about everyone else's safety.
They can say you were only focused on hitting the target, not on the playground 50 yards behind it. So how does good training fix that?
It makes 360-degree awareness part of every single drill. Defensible training emphasizes safe shot selection, timing, and, this is critical, knowing when not to shoot.
So it's about moving to find a better angle.
Or waiting a second for the threat to separate from a bystander.
Yeah.
Shows the jury that you were thinking about public safety, not just your own. It proves you were responsible, not just a trigger puller.
Okay, we've covered the mechanics, the environment. Now we get to the part that is. It's just so critical. This is where the legal fight is really won or lost. Mistake number 5. No emphasis on articulation. The legal why.
This is the absolute heart of the matter. If you cannot explain why you used deadly force, then in the eyes of the law, your actions were unreasonable. Full stop.
And articulation is just the ability to explain it clearly.
Yes, to explain the other person's ability, opportunity, and intent to cause you serious harm, and why you had no other reasonable choice.
That does not come naturally when your adrenaline is pumping. If you skip articulation training, you could be 100% justified, but the state will just frame it as a panicked, emotional, unreasonable act.
So the training has to bake this in. You need to learn how to see those 3 key elements, sometimes called the AOI test.
Ability, opportunity, intent.
Right. Ability, do they have a weapon or a huge size advantage? Opportunity, are they close enough to actually hurt you? And intent, are they demonstrating an immediate threat? Good training makes you, right after a drill, verbally explain what you saw.
So instead of just saying, I was scared, so I shot, which sounds like pure emotion,
Right.
you can say, he closed the distance, he raised the pipe over his head, that's ability and opportunity, and he screamed he was going to kill me, that's intent. I perceived an immediate threat of serious injury.
That is the language of objective reasonableness. And the training has to cover what happens after the incident, too. You have to avoid those emotional, really damaging statements like, I wish I'd shot him sooner.
Or I finally taught that guy a lesson.
Oh, yes.
Yeah.
Those words become instant proof of malice, even if the shooting was justified. The training needs to give you a script. Secure the scene, call 911, and say only what's necessary. I was attacked, I defended myself, he has a weapon, I need a lawyer. That kind of discipline is taught. It is not instinctive.
That's a huge takeaway, moving from the mechanical to the verbal.
Okay, let's wrap up with the last 2 points, which are more about the administrative side of things. Mistake number 6. Poor or non-existent training documentation.
In court, your training record is evidence. It's that simple. If you're in a shooting, they will subpoena everything. They want to know how often you trained, who taught you, what they taught you. They're building a profile of you.
And if you went to a cash-only, no-records kind of place?
It creates a huge hole in your story.
Yeah.
It lets the other side argue you weren't serious, that your training was unverified, probably substandard. It makes it easy to paint you as an amateur who just wanted a cheap way to carry a gun.
So the records need to be more than just a certificate. We're talking curriculum outlines, instructor bios, maybe even your own range logs.
You're building that bulletproof narrative of ongoing, serious, documented training. You want the physical evidence of your effort to be there when your judgment is being questioned.
Which ties everything together with the final mistake, number 7. Choosing a school based only on price and convenience. This is the cold, hard reality check from the source material. Those low-cost, high-speed programs, the ones that advertise the fastest or cheapest permit class, they have to cut corners somewhere.
And what's the first thing to go?
The expensive, time-consuming stuff. Live fire time, low-light training, real legal instruction, and professional documentation.
So by saving $100 on the class, you're actively giving up the very things that make you legally defensible. You create a weakness that could cost you thousands in legal fees. Or
Your freedom. The core message from all this research is that the focus has to be on value, safety, and legal defensibility, not price. An investment in good training with licensed instructors and scenario work is an investment in your legal future. It's a risk mitigation strategy.
This whole deep dive has, for me, completely reframed what it means to be a responsible concealed carrier. Your training isn't just about the mechanics of drawing a gun. It's going to be examined, dissected, and used to build a narrative about your judgment.
The main argument here is that training has to go way beyond the state minimums. It has to actively bring in the legal, the psychological, the tactical realities of a violent encounter. It has to turn you from someone who simply can shoot into someone who is prepared to justify shooting under a microscope.
It's about proactively building your own legal defense long before anything ever happens.
And that really leaves us with one last thought for you to think about. If the defensive training you're looking at is focused only on how fast or cheap it is, you have to ask yourself, what kind of story does that create for you in court? Is it a story of preparation or a story of negligence? As the sources say, you should train like your freedom depends on it, because in the worst-case scenario, it just might.